honorable court is now in session. Please be seated.
Welcome to the afternoon session of the Tennessee Supreme Court. We have one more case this afternoon, but I believe before we do that, Justice Campbell has a guest she'd like to introduce.
Thank you, Chief Justice Page. Yes, I would like to recognize Asher Huffman, who is here today to see arguments. He is in the 6th grade at the University School here in Nashville, and I'm delighted that he is interested enough in our system of government that he took the time, and that his mother took the time to bring him here today to see this. So he has already participated in a mock trial summer camp, and he serves on the Quiz Bowl team at his school as well. So perhaps we will see him at the podium in not so many years. But thank you for being here, Asher. I hope you enjoy it.
Welcome. We're all glad to have you. I'm not sure this will make you want to be a lawyer, but we hope so. Mr. Hibney, you may call our case, please.
Robert Crotty et al. Versus Mark Flora, M.D.
Need to do anything to start the time, or I guess you don't?
Just start.
Okay.
Yes, go ahead. Yes.
Good afternoon, Your Honors. May it please the Court. My name is Renee Stewart, and I'm here on behalf of Defendant Mark Flora in this case. I'm joined by Craig Sanders, who is amicus counsel for the Tennessee Defense Lawyers Association. We'd like to split our time today evenly, the first 24 minutes, reserving 6 minutes for rebuttal.
All right. Thank you.
We have two issues before the court today. Mr. Sanders will be addressing the recoverability of medical expenses under the Health Care Liability Act. I will be addressing the inherent conflict between the Health Care Liability Act and case law in Tennessee regarding comparative fault allegations against non-party healthcare providers. Due to inconsistent requirements between the Health Care Liability Act and decisions of this court and other courts, a defendant in a healthcare liability case is both prevented from doing something by statute that he is required to do under the case law. And that simply can't be a position defendants can be in and be able to defend their cases. Defendant is asking this court to hold that because of the requirements of the Health Care Liability Act, which came into being after this court's decision in George v. Alexander, a defendant should be able to introduce evidence, causation evidence, regarding a non-party's role in causing a plaintiff's injury when that non-party complied with the applicable standards of professional practice. Under prior cases that would have been considered blame shifting, specifically George v. Alexander and subsequent cases interpreting that.
Can you speak up a little bit or get closer to
Certainly,
the
yeah.
mic, maybe?
Thank you for letting me know. If I start to yell at you, let me know that as well. To hold otherwise would be to unconstitutionally deprive a defendant of his ability to defend himself in a case by specifically excluding exculpatory causation evidence that a defendant is unable to provide under the statutory framework. Accordingly, we ask this court to reverse the trial court's decision in this case, excluding such evidence, but more broadly hold that defendants in other cases should be able to introduce such evidence. This is not a fact-specific case, but I would like to address the facts briefly. Mr. Crotty had an impacted kidney stone. It was removed by Dr. Flora in a surgery. Mr. Crotty had a lengthy and complicated and difficult recovery following that. Complications occurred, and ultimately he lost his kidney about a month after Dr. Flora's surgery. He filed this healthcare liability lawsuit, and Dr. Flora, in defending himself, denied that he failed to comply with the standard of care and specifically stated that he did not cause the injury that the plaintiff alleged. He did not assert comparative fault against any non-parties because he did not feel and still does not feel that any other healthcare providers failed to comply with the standard of care. And neither Dr. Flora nor any of his experts in this case have ever stated as such. If we look back, the reason why Dr. Flora was sued in this case, it's simply due to a mistake of fact. The subsequent treating surgeon, Dr. Mitchell Wyattrek, operated on Mr. Crotty about a week after Dr. Flora did. He, by his own admission, this was a difficult surgery. It was confusing. It was disorienting. It was harder than he had ever experienced this type of procedure to be. In dictating his operative report, he made an assumption based on his understanding of the circumstances at the time that he now knows to be incorrect, and he stated as such in his deposition. Specifically, the conclusion in the operative report that led to this lawsuit was that Dr. Flora had misplaced a stent. A perforation of a ureter is not negligence. That is undisputed in this case. What may be negligence is perforation of a ureter by misplacement of a stent. And therefore, plaintiff believed, based on this operative report, that Dr. Flora was negligent and filed the suit. It was not until Dr. Wiatrek was deposed that he himself realized the error in his report. He went back and looked at the medical records, but more specifically and more importantly, he looked back at a preoperative CT scan that told him that the stent was in the right place, and he stated as much in his deposition. Now, if Dr. Flora was sued based on a mistake of fact, he should be able to introduce to this jury what that mistake was and how it impacted the plaintiff's care and the expert opinions in this case. It's important for this court to know that Dr. Wiatrek's error in his operative report and the complications that occurred during his surgery were not negligent. No one is saying that they were. It does not mean a bad outcome, does not mean negligence. Even the plaintiff's own expert has agreed that Dr. Wiatrek at all times complied with the standard of care. That is undisputed in this case.
Could you speak a little bit to why, in your view, George is distinguishable? And if it's not, and I guess I would just be interested in I think you've outlined it in your brief, but if you could just clarify what your position is on whether we need to abrogate George, at least in part, in order for us to hold that Rule 8.03 did not require these facts to be pleaded in your answer.
I'd be happy to. I think really the most important part of George is the concurring opinion by Justice Reed, who points out that a general denial should always be admissible, and that the distinguishing thing about George that he pointed out was that wrongful conduct was being alleged by a non-party, and that is not true in this case. If wrongful conduct is being alleged and someone is in fact asserting fault, blame, wrongful conduct against non-party, that should be required to be asserted under 8.03. Under the goals of McIntyre versus Valentine, the court wanted to tie...
But the actual holding in George is to the contrary, right?
I'm sorry, say that again?
The actual holding in George is to the contrary, right?
Yes, Your Honor.
I mean, I do want to hear you answer Justice Campbell's question directly about whether the facts in this case are distinguishable in any significant way.
Well, like I said, the main distinguishing factor is that wrongful conduct was being alleged in George, where there is no wrongful conduct here. And since George, we actually have had the Health Care Liability Act, which does say that they've made more stringent requirements on what it takes to bring someone into a lawsuit, the pre-suit investigation, the certificate of good faith requirement now.
Do we need to abrogate George in any way to get where you think we ought to be?
Yes, Your Honor, I believe you do. George has gotten, and the subsequent case law has gotten so far afield by the original principles behind McIntyre, which was to closely tie liability and fault. In this case, there is no fault by Dr. Wiatrek or any of the other subsequent healthcare providers.
Could the other parties be put on notice by a certificate of good faith to just frankly said exactly what you're saying? There's no fault, but there's causation?
If I understand your question, the certificate of good faith has two requirements. You have to say that there has been a deviation in the standard of care, and then there simply was none. So defendant cannot, under the law, submit a compliant certificate of good faith in this case. If he did a faulty one or none one at all, the plaintiff could move to strike his allegations and we'd be exactly where we are.
Go ahead.
Go ahead, Justice Kirby.
No, go ahead.
Well, so as I understand plaintiff's position, it's that 8.03 may apply and require this to be pled in the defendant's answer, but that doesn't mean that that doesn't necessarily mean that the good faith certificate requirement also applies. Why is that wrong?
Well, first, that they need to be read in conjunction. I mean, the statute specifically says these are a requirement. This is a requirement for a defendant who wants to assert comparative fault.
Well, doesn't it say, I mean, so the good faith certificate requirement says that if expert testimony is required to prove fault as required by 2926-115.
And it is.
So your position would be that it is required here. If you read fault to, I guess, include the sort of allegations that we're talking about in this case, then you would necessarily have to read that phrase to include the sort of testimony that you want to introduce in this case.
Correct, Your Honor.
Okay.
And in fact, if we use the standard of what caused or contributed to a plaintiff's injury, that is overly broad and untenable. That would implicate all of the subsequent healthcare providers in this case, the radiologist who did the CT scan, the ER doctor who saw him, the urologist who saw him in the office and did an X-ray.
But the point is, does Section 122 actually apply?
Section 122 would apply if Dr. Flora were intending to bring in any other defendant to this case, saying that that defendant caused or contributed an injury and failed to comply with the standard of care. Here, we're just saying that all of the subsequent care caused or contributed to the plaintiff's injury, and that it wasn't successful. Even Dr. Shull, the one who removed the kidney,
Can we agree that Rule 8.03 and the Healthcare Liability Act statutes involved all are geared toward transparency,
Yes,
toward defendants not hiding the ball, and plaintiffs not hiding the ball, for that matter. Everybody disclosing at the earliest possible stage, and in fact, the Healthcare Liability Act requires the plaintiff to disclose before they even file the lawsuit. How does your and so we have to interpret all of them, both Rule 8.03 and the statutes, in light of that overarching goal. Isn't your proposed interpretation contrary to that aim?
It is not, and I'm glad you brought that up because there's an important point I wanted to address today. Specifically, I think the original goal behind 8.03, and I can quote the Supreme Court if you like, it is to apportion fault in a case based on the negligence of the plaintiff or non-parties. Comparative fault is the apportioning of damages among multiple or joint tortfeasors, which we don't have in Dr. Wyattrek here, according to the percentage of fault attributed to those persons. Now, Dr. Flora is not.
So you think the fact that the defendant only says that Dr. Wyattrek is not a tortfeasor should control? Is that right?
Yes, Your Honor. That there is no wrongful conduct means that there is no assertion of...
But obviously the premise of the lawsuit is that the injury resulted from negligence.
Yes, Your Honor. And Dr. Flora should be able to say, I was not negligent, without having to say, but it was someone else who was negligent. He can just say, I wasn't negligent, and here's how we know that.
The whole premise of George is that if you are contesting the element of causation, then you are essentially contesting fault.
Yes. Yes. So the key here in that plaintiff has alleged there was a trial by ambush, and that's why we need to assert it in Rule 8.03. Because of the Healthcare Liability Act, the legislature has put in requirements to, first of all, prevent that because of precedent investigation. But more importantly, we have the discovery rule, Your Honor. At numerous stages throughout this lawsuit, the plaintiff was put on notice and had the information in which he could have brought Dr. Wyattrek into the suit if he should be a defendant, if he engaged in wrongful conduct.
Counsel, your time's up. Thank you.
I apologize. I thought I had 30 seconds. So anyway, thank you, Your Honors, for your time.
The clock is going up, see? Oh, you missed it. All right. That's all right.
May it please the court, I'm Craig Sanders, counsel for the amicus Tennessee Defense Lawyers Association. I'll be addressing the second issue in this case, which is whether a plaintiff in a healthcare liability case can recover discounted or written off medical expenses that neither the plaintiff, his or her insurance company, nor anybody else has paid, owes, or will ever pay. This case decided the Dedman versus Steelman case several years ago. That case was an automobile accident case, but this case noted, or this court noted in that case, that healthcare liability cases are different, that there's a statutory exception, an abrogation of the collateral source rule in healthcare liability cases. Nonetheless, the trial court in this case stated that the collateral source rule is in full force and effect, even though it's undisputed this is a healthcare liability case. In 1975, the General Assembly passed the Healthcare Liability Act, including 2926-119. That's the purpose of passing the act was there was a perceived medical malpractice crisis. This court has recognized that was the purpose of the act in several cases, including the Harrison versus Schrader case. And to try to combat that perceived crisis, the legislature passed several statutes, including this one, to keep doctors practicing in Tennessee, to keep medical malpractice costs down, to keep healthcare costs down. To do that, in part, the legislature said in healthcare liability cases, damages are different. There's going to be limited. You will not be able to recover the same things you can recover in other personal injury cases.
Counsel, can I ask you a question about the procedural posture of this case? Is that on this issue, it's just a motion in limine on the evidence, right? I mean, it's not the substance of what is recoverable. The collateral source rule has a substantive aspect to it and an evidentiary aspect to it. The statute that you're talking about addresses the substance of what's eventually recoverable. But normally evidentiary issues, especially pre-trial, are abuse of discretion standard. So please address that.
Yes, Your Honor. You are correct in this case that the issue arose via motion in limine, and the trial court denied the defendant's motion in limine seeking to exclude evidence of these written off or adjusted expenses. However, the trial court in this case denied that motion because the trial court ruled that the collateral source rule is in full force and effect and that you can recover these expenses. So while it is a motion in limine, the reason behind the motion in limine is that the trial court is misreading or misconstruing the statute.
Well, but still, we're reviewing a discretionary ruling in advance of trial. Let me flesh this out a little bit. The collateral source rule says from an evidentiary standpoint, from a substantive standpoint, the plaintiff can recover the full charges. From an evidentiary standpoint, for separate reasons, it limits the evidence that comes in of insurance, for example. So if there's no collateral source rule, then there's no restriction on what evidence can or cannot come in, right? But if I understand it correctly, what you are asking us to do is basically go to the other end of the spectrum and adopt something that's the converse of the collateral source rule, that it's not simply removing from the picture the collateral source rule, but instituting a new rule that says the plaintiff can't put into evidence the full undiscounted charges. Am I understanding you correctly?
I think what we're asking this court to do is to interpret and apply 2926-1.
But isn't that the end result of what you are asking us to do?
I think the court would then be able to send the case back and let the trial court reevaluate whether that evidentiary ruling is now okay based upon the court's interpretation, because the trial court's interpretation of the statute is you can recover these, and that was the basis for the evidentiary ruling.
But what you're asking us to do is require the trial court to restrict the proof. As I understand it, there's an issue in this case about whether there's insurance, whether the plaintiff paid, that sort of thing. And so you're saying on the front end that the trial court abused his discretion.
I don't think it's an abuse of discretion. I don't think this court has to go that far. I think this is a...
Well, then what are we doing? Are we just...
I think you would be correcting the trial court's wrongful interpretation of the statute.
Are you not asking us to reverse the trial court's ruling on the motion in limine?
Yes, because of what it's based upon.
Could we vacate that ruling? I mean, in other words, so we wouldn't necessarily be saying that the trial court should have ruled differently on the motion in limine, but that this piece of its analysis was incorrect. So we're going to correct that and then send it back.
Yes, Your Honor, I think that's...
For reconsideration.
I think that's what this court can do and let the trial court know, no, this statute does not permit a plaintiff in a health care liability case from recovering these adjusted damages like the court, which is the basis for the court's ruling, and let the court reevaluate the admissibility of the evidence after that ruling by this court.
But Justice Kirby referred to some potential factual disputes that exist in this case, and I do want to talk a little bit about those. And if you could just maybe state your position on kind of the state of the record with respect to the insurance premiums. And also, sorry, not to load too much into this question, but I am interested in how you interpret the phrase insurance purchased in whole or in part, privately and individually, and whether that includes a situation where a private individual helps pay the premiums for an insurance plan provided by his or her employer.
Regarding the facts, I don't think it's disputed in regards to what is really at issue, which is that there's an amount of adjusted or written off expenses that neither the plaintiff nor the insurance company owes or paid. So I think that's really the only pertinent factual issue, and I don't think that's in dispute.
So are you saying it's not, there's no dispute over the insurance, to the extent an insurer has paid part of these costs, whether
Correct.
those are properly includable?
Correct. We're not disputing that if a plaintiff pays for his or her insurance, that the plaintiff can recover the amounts that insurance company paid. And that's consistent with the line of cases starting from this court in the Nance case, moving forward. We don't dispute that.
How do you get that from the statutory language, though? That's what I'm curious about. Because when I read that language, my initial instinct, at least, is a little bit different. But I'm interested in your view on that.
The statute, if you look at the first part of the statute, a plaintiff can be awarded actual economic losses suffered by the claimant. Everything after that is subject to that first line. So if it's not an actual economic loss, which is the exact statutory phrase, then you can't recover it.
No, I get that. I guess, let me just clarify the nature of my question here. I guess I would read insurance purchased in whole or in part, privately and individually, to be referring to a completely private individual insurance plan, not an employer-provided plan, because government or private or government employer plan is referenced elsewhere in 119.
And I don't think that's disputed. So whether it's an employer-provided plan or a private plan purchased by the plaintiff, we don't dispute you can recover the costs paid by that insurance company, and that's consistent with the statute. There's three things the statute requires. It has to be an actual economic loss, it has to be suffered by the plaintiff in some form, and it has to be paid or payable, and that's the second part.
Well, but the government or private employer part of it, I mean, that they can't recover that, but they can recover the insurance purchased in whole or in part, privately and individually.
If
right?
that insurance company paid,
yes,
and
exactly.
so then there's an actual economic loss. Yes, I think they can, but that's not the adjusted expenses.
No, I know, I agree. So I'm not, that's not my issue, I guess. I'm just trying to figure out from that statutory language at the end of 119.
I think that's what permits the plaintiff to recover when he or she buys insurance, the amount the insurance company pays.
Well, how is this the right case to reach that kind of issue? This is a motion in limine prior to trial, and you're basing your whole argument on a remark that the trial court made on his reasoning, which could change during the course of trial. The statute does not deal with the evidentiary issue. It just doesn't. It deals with the substantive aspect of the collateral source rule, not the evidentiary aspect. So you're asking us, in a motion in limine, when there's all these facts about, you're very reassuring, it's not really disputed, this and that. Trials play out differently. I can see that we might need to reach this issue after a trial, but you're talking about a motion in limine with a very limited record and fleshing out the substance of this statute that doesn't even address evidentiary. You want us to not only address the substance of the statute, but go further than that and imply from the statute a whole evidentiary apparatus that keeps the plaintiff from putting some things into evidence. How is this the right case for us to go that far?
If you look at the cases that have addressed this, including the federal cases that are directly on point and that specifically...
Those go to the substance, not the evidentiary rule.
Those cases, it arose on a motion in limine. And that's when you see this issue arise, because the plaintiff wants to put on proof of what medical expenses he or she can recover. And the trial court's trying to keep out or allow in, the medical expenses that are recoverable. So this just happens to be the way it arises.
Counsel, this is Justice Lee. Was there a offer of proof, any details in that motion in limine, so we know exactly what we're dealing with here? Otherwise, it really sounds like you're asking for us to give an advisory opinion on medical bills that may or may not be recovered or introduced. And I think that goes to Justice Kirby's question.
You may finish the answer.
Thank you, Chief
Go
Justice.
ahead.
The issue always arises, or almost always, on a motion in limine, but we need clarification in regards to what the statute means, and that's where the trial court said the collateral source rule is in full force and effect, and that's contrary to this court statement in Dedman, as well as the language of the statute and the line of cases that talk about that you can recover these medical expenses that an insurance company pays. That's the exact language.
But do we know from the record which provision of this statute would apply in terms of whether it's a private pay, employer-sponsored plan, or whatever? Do we know that from the record?
Ms. Stewart may be able to address the record better than I can. My understanding is that it's undisputed there's an amount that's been written off, and I think that's really all that's important in regards to the court's ruling, that there is an amount that's written off that neither the plaintiff, his or her insurance company, nor anybody else owes or will ever have to pay.
Thank you, Mr. Sanders. Go ahead.
Good afternoon. May it please the court. My name is Ben Miller. I represent the plaintiffs. I'd like to take up the issues in the order that they were first presented, talk about Dr. Wytrek first. I understand why the defendant could not specifically plead that Dr. Wytrek was at fault. That's not their argument. They don't have the support for it. The statute says, as Justice Campbell pointed out, that if a defendant is going to assert that a non-party is at fault, and expert testimony is required to prove fault, certificate of good faith has to be filed. What I don't understand is why the defendant could not plead that Dr. Wytrek was the one who caused Mr. Crotty's injuries. That's their argument. They do have support for it by way of Dr. Flora himself, by way of their experts. And the statute doesn't say anything about having to file a certificate of good faith if all you're trying to do is talk about somebody else causing the injuries at issue.
And you just do that in your 803 response, is that what you're saying?
Yes, sir. If the legislature had intended that to be when you have to file a certificate of good faith, they easily could have had this language track the language of 20-1-119, which says that any time a defendant raises in an answer or an amended answer that a person not a party to the suit caused or contributed to the injury or damage for which the plaintiff seeks recovery. But that's not what the legislature did in the healthcare liability statute, in the good faith and certificate of good faith. So the court should presume that difference was intentional and meaningful. And it makes sense because a certificate of faith surely isn't required when a defendant simply wants to say, whoa, 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 you've got the wrong party here. Similar to what happened in Bidwell. The physician defendants in that case weren't trying to point out that their actual employer, Erlanger Hospital, was somehow at fault. They were merely trying to say, you've got the wrong party. So if there wasn't anything preventing the defendant from pleading their defense, the question becomes whether they were required to, and the answer is yes. And I'll point out here that the defendant raised in their reply brief for the first time, the issue of, well, maybe under Bidwell, I did actually plead that after all. But that was the first time that issue's been raised, and it should be deemed waived by the court. Because the defendant's position all along is that he should be able to make this argument to the jury. He just shouldn't have to put it on the record in the pleadings. The problem, of course, is that cases are tried based upon issues in the pleadings. And in fact, if issues end up getting tried that aren't in the pleadings by consent, Rule 15.02, Tennessee Rules of Civil Procedure say, well, they're going to be deemed to have been, they're going to be treated as if they hadn't pled in the first place. But more important to this appeal is that pleading that a non-party caused the plaintiff's injury is usually the only opportunity the plaintiff has to act if it appears that non-party may actually bear some responsibility for the injuries. So consider this court's admonishment in George. Rule 8.03 is a prophylactic rule of procedure that must be strictly adhered to if it is to achieve its purposes. It is designed to obviate the need for appellate courts to look into the record for actual prejudice each time a defendant introduces proof at trial of an unpleaded defense. So that's what the trial court did in this case. It followed this court's admonishment and held that the defendant could not introduce proof at trial of his unpleaded defense that Dr. Wytrack was the one who caused Mr. Crotty's injuries. That was the correct ruling, and the court's review should stop there because any argument as to, well, what would have happened if he had tried to plead his defense is purely speculative. There are lots of different directions that could have gone. Plaintiff could have decided, even if it had been pled, Dr. Wytrack was the one who caused these injuries. Plaintiff does not have to, as this court has made clear before, plaintiff doesn't have to bring Dr. Wytrack into the case. Plaintiff has the opportunity to make a decision, say, maybe on the one hand, I don't want to bring in another defendant, another defense lawyer. They're just going to team up against the plaintiff, make my case harder. Then the parties proceed to trial, the defendant gets to make their defense, no harm, no foul. Alternatively, maybe the plaintiff realizes when that defense gets pled, wow, you're right, Dr. Wytrack really is the correct defendant here. I'm going to drop my case against Dr. Flora, I'm going to bring Dr. Wytrack in, I'm going to pursue him instead. Or maybe the plaintiff says, you know what, I'm not sure, better safe than sorry, I'm going to go ahead and bring Dr. Wytrack in, the parties go forward with discovery, with their experts. Maybe Dr. Flora, after all that gets done, says, you know what, I do want to try to allocate some of this responsibility to Dr. Wytrack. Or finally, maybe the plaintiff just says, there's no case here. Now that we've been through all this discovery, we've had all these parties involved, what Dr. Flora was saying all along is true. Dr. Wytrack was the one who caused these injuries, but there was no negligence involved, so I got to let this case go. The point is we'll never know because the defendant never gave the plaintiff the opportunity to make those decisions, and that opportunity is what 20-1-119 is all about.
Mr. Miller, if I could interrupt you for a second, I'm
Yes.
wondering if you could explain why, in your view, the rule announced in George is consistent with the actual language of Rule 8.03. I mean, was it really grounded more in kind of policy concerns that we want to incentivize defendants to provide this information in their answer, or is there a way to actually root it in the text of Rule 8.03?
I think there's a way to root it in the text of it because 8.03 is not just limited to comparative fault. It applies to any matter that constitutes an affirmative defense. And I think whether or not you say, I'm going to plead that this person is at fault, they were negligent, or whether you're just going to say, as part of my affirmative defense, I'm going to point the finger that you got the wrong party in this case, and this other person was the one who really caused you harm. So I think that's where it all makes sense in terms of what George was saying and how it's still consistent, because these are just the very basics of pleading.
But is that really an affirmative defense? I mean, isn't that just negating an element of the plaintiff's claim?
I don't think it is any more so than comparative fault would be. Comparative fault is, again, just pointing the finger at somebody else. It says, it wasn't just me, it was me and somebody else who should bear responsibility. But
that's sort of acknowledging that, okay, perhaps you can satisfy the elements of your claim against me, but here's why I shouldn't be saddled with all of the liability, right? And I see this as a little bit different, because you're not sort of acknowledging that the plaintiff may be able to prove all of the elements of his claim. You're actually trying to negate one of the required elements of the claim.
Well, I think that if somebody is trying to say, I was not the cause and fact of your injury, somebody else was, to me, that strikes me as an affirmative defense, to say, I'm going to negate the cause and fact, the proximate cause part of your claim by introducing proof, evidence, that somebody else fit that element. And I think that's where, some of the cases that have gone on to either follow or distinguish George have made that distinction and said, well, we got to look at, does this fit? There was a case involving a product liability claim, and the court said that didn't trigger it. That did not trigger the obligation to assert comparative fault because it didn't fit part of the plaintiff's claim. But that's what we are talking about here is part of the plaintiff's claim in this healthcare liability action is who caused this harm from what is undisputably a surgery, whether it was the surgery done by Dr. Flora or the surgery done by Dr. Wytrack. So it's part of it, and if Dr. Flora wants to attempt to negate the part of causation by saying it was somebody else, he could just deny it. I mean, that would be part of it. He could say, look, I didn't cause you any harm. I did everything right in my surgery. He doesn't have to come out and start saying, and I can point to where it went wrong, where you did actually get this harm. And so I think that's where it's distinguishable.
But you would say, so just to clarify, you would say that that's, he's required to plead that, the defendant, is required to plead that because it's an affirmative defense within the meaning of Rule 8.03, not because it's comparative fault.
Yes.
Or do you think it's both?
Right. Yes.
You would root it in the other affirmative defenses kind of catch-all language.
I think so, and I certainly recognize that we have to be careful about what comparative fault means because, as this court pointed out in Bidwell and in a history of cases that followed there through, the court was willing to say that the mere pointing of the finger at somebody else does trigger the comparative fault saving statute. So I recognize that there's a little bit of disjointedness there, but we have a long line of cases that stands for that proposition, the most recent of which is Bidwell, that says that whether
but
you...
I want to understand what you're saying because I guess the gist of what I thought the holding in George was that if you are contesting that somebody else caused the injury, then you are, for purposes of 8.03, asserting comparative fault. Am I wrong in that? I mean, you're saying it's based on affirmative defense, but I just didn't read it. I just didn't read George that way. But
I think it is a recognition of fairness and always having the backdrop of 20-119, which is the whole purpose is to interpret that statute very liberally and broadly in the interest of fairness.
Well, I'm talking about the application of Rule 8.03.
Yes, Your Honor. And I think that the way that the court got to 8.03 was to say, you even if you are not going to specifically allege fault, even because that was still the argument was that we are not.
Yeah, the defendant's like, oh no, I'm not saying he's at fault.
That's right. And so the point of George was to say, well, you can always say that, and that's not going to be a way to get around this. The point of...
But wasn't that its application of 8.03 and not the statute? Maybe I'm misremembering, and I might be.
Well, that is where they got to the obligation to plead it. Right. Okay, and because they have to work together, they have to be read together, because pleading it, like I said before, is the only way to trigger the statute.
But
that's it.
Back to Justice Campbell's question, didn't that relate to the comparative fault part of 8.03?
It did.
Yeah, that's
It
right.
did. It did. And
Okay.
but again, you know, what we've seen through, like I said, Bidwell is even the mere pointing of the finger at somebody else, naming somebody else. It wasn't me. It was somebody else. Not pointing, not blaming anybody. There's no fault being attributed here. That is sufficient to trigger the statute. It is required to be pled under 8.03. I want to turn and talk about the bills, and I think the most important point here is that 2926.119 is in derogation of the common law, and therefore it must be strictly construed, meaning it should be interpreted to alter the common law no more than is necessary. And of course, the common law that we're talking about is the collateral source rule, which sought to prevent, basically at its core, a defendant from receiving a windfall when the harm caused might be more than the actual net loss to the injured party. So 2926.119 was enacted. The way I view it is essentially it's a no double dipping unless you bought the dip statute. And we see that from Senator Davis's explanation for why they added in these exceptions. And he says, we believe it'd be better to exclude some of these benefits that a person can already claim under employment or some other benefits. But if he pays part or partially for some of these benefits, for disability otherwise, he should be allowed to collect those and that they not be deducted from the settlement or the judgment or the verdict, as the case may be. So, in other words, if a plaintiff has already collected unemployment to replace lost income, plaintiff isn't going to be able to double dip and claim that lost income in the case. That would be a double dip, and that's where we've got this partial abrogation of the collateral source rule. Because under the collateral source rule, plaintiff would be able to double dip. There wouldn't be able to be any evidence of the unemployment benefits. They'd be able to claim those lost income even though it had already been replaced. On the other hand, if the lost income was replaced by privately purchased disability insurance, the plaintiff should still be allowed to claim that lost income, even though it's going to result in a double dip. And that's what Senator Davis was talking about here. And the same is true of medical expenses. If a plaintiff has free employer-provided insurance, whether through a private employer or through the government, to the extent, and that language is important, to the extent the bills are paid or payable by that insurance, the plaintiff does not get to double dip and claim the portion of the bills that was paid by the insurance. That would be a double dip because, and the plaintiff didn't, make any arrangement or was not responsible for the fact that there was this 100% provided employer insurance that stepped in and did it. So it would be a double dipping there. But there's two.
Just to clarify, so it has to be 100% provided.
For this statute to come into play and say no double dipping, you don't get to claim the portion paid by the insurance company. Basically, yes, the plaintiff could. It has to be true that the plaintiff didn't contribute to that insurance.
But if the plaintiff contributes even 1% of that premium, then you would say that falls in that latter part of Section 119, the in whole. Where's the language? Insurance purchased in whole or in part, privately and individually.
Exactly. If it was privately purchased insurance, the plaintiff, it comes back to the collateral source rule. Plaintiff gets double dip, they get to claim those payments.
What does and individual? I'm sorry.
Under this record, do we know what type of medical bills we're talking about, which exception would apply?
To clear up the questions about the record, I can also confirm that Mr. Crotty had insurance through his employer who, and he paid premiums. His premiums, like so many of us, his premiums were deducted from his paycheck, so he contributed towards the premiums for that insurance. So the medical bills at issue, and I can't cite you the specific numbers, but yes, his insurance covered the medical bills at issue. And there is going to be a discrepancy in the amount that the insurance company actually paid and what was actually billed by the providers. I think it's important to point out that this whole notion of no double dipping is also consistent with case law that says that even if a plaintiff has free insurance through an employer, if there's a right of subrogation, in other words, the insurance company has a right to come back and get that money back, the plaintiff there does still get to claim those amounts, even if they didn't contribute to it at all, because it wouldn't be considered a double dip.
Well, do you think this is, I mean, I personally, I speak only for myself, but I'm bothered by reaching all of these complicated interpretive questions about what eventually can be recovered based on just a motion in limine about whether the plaintiff can introduce this or that is normally reviewed on a completely abuse of discretion standard. Address that, if you would.
Yes, Your Honor. I agree with you that this was a motion in limine, an evidentiary ruling that is to be reviewed on an abuse of discretion standard. That said, I recognize that this is a very important issue, and I'm not suggesting that this is the case, but the case is here despite my opposition to the application for permission to appeal. I recognize that this is a big issue that, although it very often does not come up until the time of trial, it is an issue that probably could help a lot of cases resolve earlier on. If everybody knew what the actual recoverable damages were going to be, and they weren't waiting until trial to know, am I going to be able to put in and claim the full amount of these entire bills?
But the evidentiary issue is separate. The statute doesn't address the evidentiary issue, and I am concerned about leapfrogging into an evidentiary, a whole advisory opinion about first interpret the substance of the statute based on facts we don't know, and then go from there to some kind of evidentiary ruling limiting what trial court can and cannot do.
Right, and I, you know,
It sounds like you're inviting us to do that.
Are you saying this is just a simple statutory interpretation case? What this statute actually means?
Absolutely, I am. Yeah, I think it's a statutory interpretation case. It is an issue that has plagued, you know, the healthcare liability bar for a long time in terms of differing their evaluations on that. So the outcomes that I have laid out stay as true as possible to the collateral source rule and alter the common law as little as necessary, which is what the court is called on to do. Not only do the opposing sides' interpretations completely abrogate the collateral source rule and unnecessarily do so, but their interpretations aren't reasonable. And I'll give you an example. Under the defendant's interpretation, that a plaintiff who has privately purchased insurance, under their interpretation, that plaintiff can still claim the amount of those insurance payments. But how is that, if their argument and their interpretation is that only actual economic losses, which insurance payments aren't, how under their interpretation could a payment by an insurance company constitute an actual economic loss to the plaintiff, especially if it's a policy where there's no right of subrogation? Plaintiff's never going to have to pay that amount back. And that is something that happens. But under their interpretation, they're saying that plaintiff who's got privately purchased insurance can claim that, even though they never personally had to pay it out. It was entirely paid by insurance. So theirs doesn't make sense. And if the legislature had intended to completely abrogate the collateral source rule or assign some new meaning to cost of reasonable and necessary medical care or actual economic loss, which are familiar terms in our business, it easily could have said so. How about a plaintiff can only claim amounts paid to the provider? That would be one way of doing it. Or the balance of discounted medical bills are never recoverable. It would have been easy to say. It would have been easy to do. They chose not to, and because the legislature chose not to go that route, neither should the court. I have finished early, unless there are any other questions. Appreciate the court's time. Thank you.
Thank you.
Rebuttal?
Your Honors, Mr. Miller has mischaracterized defendant's position in this case. He's saying that Dr. Flora is saying you sued the wrong party, and that has never been Dr. Flora's position. It's not an either-or proposition or we should share fault here. Dr. Flora's position is that all of the care was within the appropriate standard of care, and no one should be sued here. Plaintiff's argument is that he was denied an opportunity to join Dr. Wiatrek in this case as a defendant. That is not true, because even plaintiff's own expert says Dr. Wiatrek was not negligent. Even if Dr. Flora had asserted in his affirmative defense that Dr. Wiatrek caused or contributed to this injury without the certificate of good faith, Mr. Miller could not have brought Dr. Wiatrek in as a party unless he himself had a certificate of good faith saying that Dr. Wiatrek was negligent. It is undisputed by all the urologists in this case that he complied with the standard of care. Plaintiff also said...
This is Justice Lee. What prevented the doctor from putting in his answer? I did not cause this, but it was caused by the second doctor. It was caused by the second doctor. Why could that not have been put in the answer? So there was, so you weren't playing hide the ball with the plaintiff.
At the time of the answer, Your Honor, Dr. Flora did not have the benefit of any of the subsequent medical records, specifically the CT scan, which showed that the stent was in the correct place.
Why couldn't defendant have amended his answer?
Well, Your Honor, what defendant did is responding to plaintiff's interrogatory. It's attached as attachment 13, number 11. If you could look at that after, it'll provide that question. Dr. Flora did say specifically, while no one else was negligent here, I do believe the injury occurred in the subsequent procedure. And, Your Honor, the safety net here is that the plaintiff has the benefit of the discovery rule. That should have put him on notice that someone else may have caused or contributed to the plaintiff's injury. He had a year in which to investigate and bring in Dr. Wiatrek.
But George has been in place all this time.
But the Health Care Liability Act has been enacted since then, Your Honor. And that is what prevented Dr. Flora from asserting in his answer.
Prevented him from asserting in his answer that someone else caused it? Come on.
8.03 is asking for a potential tortfeasor. At no time has anyone identified Dr. Wiatrek as a tortfeasor here. He is the subsequent treating physician, just as Dr. Shelton.
The holding of George does not say that. So I'm not understanding how you're saying that the defendant was constrained from including that in his answer.
It would have been a futile exercise, Your Honor. All plaintiff had to do without that certificate of good faith is to file a motion to strike, and all causation defenses are prevented from being argued. I see my time has passed, Your Honor. Unless there's any final questions, I'd like to turn it back over to Mr. Sanders. Thank you.
Thank you.
The statutory language is not double dipping. It does not use that language in the statute. The General Assembly elected to put in the statute actual economic losses suffered by the plaintiff that are paid or payable.
You think that phrase is ambiguous?
I do not, Your Honor. Certainly anytime you draft a statute, there's different phrases you could use, but I would defer, or I would reference the federal district court, Judge Thomas Anderson, in the Nalawagan case. He said it's, quote, sufficiently clear, that language, and I would agree with him. I would like to address briefly the issue about private insurance versus employer-covered insurance. That seems to be an issue with the court. There's a line of cases, and what we're asking is consistent with both of them, and that's from the Tennessee Court of Appeals in this court, that essentially say this: if the coverage is provided, even if you didn't pay for it, if you have to reimburse who paid the expenses, then you can get them under the statute. And the same is for the insurance. If you bought the insurance and they paid it, then you can recover it. That makes sense, and it's consistent with the statute. Mr. Miller referenced some legislative history, and that comes from the Steele versus Fort Sanders anesthesia case that's referenced in the plaintiff's brief and the defense brief. And that court talked about the legislative history that Court of Appeals did, and then held this. It said, quote, "We are of the opinion from the legislative history that it is expressly intended that benefits paid by insurance partially purchased by the employee should not be excluded." So what those cases say is if it's paid for, then the plaintiff can get it. And that's consistent with the statute. It's consistent with the purpose behind the statute. It's consistent with this court's statements in Dedman. It's consistent with the case law throughout. But what is inconsistent with each of those things is allowing the plaintiff in a health care liability case to recover these written off or adjusted expenses that nobody pays. Thank you.
Thank you. All right, that concludes our afternoon session.
All rise.
Asher didn't run away, so I guess he enjoyed it.